The timestamp on the court filing showed 3:47 a.m., but I had been home asleep since midnight. I stared at my monitor in the pre-dawn darkness of my corner office, watching the cursor blink against the impossible data. Zachary Wellington, 42 years old, education law partner at one of Charlotte's most prestigious partnerships. 20 years of practice had taught me to trust documentation. This morning, that trust felt misplaced. The case management system displayed a motion for summary judgment in the Henderson School District matter, filed electronically at 3:47 a.m. on Tuesday. My digital signature appeared at the bottom, crisp and authentic. The problem was simple. I had never written this motion. I pulled up the original draft from my secure files. Different language, different legal arguments, different outcome entirely. Someone had created an entirely new document, stamped it with my credentials, and submitted it to the court while I slept. My hands moved across the keyboard with practiced efficiency. Access logs showed my user credentials active at 3:43 a.m. 4 minutes to log in, upload, and file a 12-page motion I had never seen. The metadata confirmed the impossible. Created Tuesday, 3:41 a.m. Last modified 3:46 a.m. Author listed as Z. Wellington. The Henderson case represented 18 months of careful preparation. A wrongful termination claim against the school board that could set precedent for educator rights across North Carolina. The motion on my screen argued the opposite position from everything we had built. I reached for my phone to call the court clerk, then stopped. Filing false documents carried severe penalties, bar discipline, criminal charges, career destruction. If this motion reached the judge's desk, my signature would be the only that mattered. The office remained silent around me. Security cameras would show I had arrived at 6:15 a.m., same as always. My keycard logs would confirm I had not been here during the night, but digital told a different story entirely. I opened the firm's billing system and searched for unusual activity. Tuesday night showed 3 hours of work billed to Henderson at premium rates. My billing code, my hourly rate. Work I had never performed on a motion I had never written. The phone rang, cutting through the morning stillness. Henderson School District Superintendent, his voice tight with confusion. Mr. Wellington, I need to understand what happened with yesterday's filing. This motion contradicts everything we discussed. I closed my eyes and felt the ground shift beneath 20 years of careful reputation building. The Henderson case had started like any other education law matter that crossed my desk at our Charlotte partnership. Zachary Aldrich, the district's general counsel, had referred the wrongful termination claim to us 6 months earlier. Standard procedure for cases involving constitutional issues and potential precedent. I had trusted our compliance advisor completely. Arabella Aldrich had joined the firm 3 years ago with impeccable credentials from the State Bar's Technology Division. She managed our case filing systems, reviewed all court submissions, and maintained our digital security protocols. Partners relied on her expertise to navigate the increasingly complex world of electronic court filings. The Henderson superintendent's call forced me to examine everything with fresh eyes. I pulled the original motion from my locked desk drawer, the handwritten notes, the research memos, the draft I had actually prepared. The document filed with the court bore no resemblance to my work. Our case management system showed a clear timeline. I had uploaded my draft Monday at 4:30 p.m. Standard protocol required Arabella's review before any court filing. Her digital signature appeared on the submission log at 3:43 a.m. Tuesday, followed immediately by the court filing. I walked to Arabella's office, finding her reviewing discovery documents with her usual methodical precision. Her workspace reflected the same attention to detail that had earned partner trust. Organized files, dual monitors displaying case tracking software, and a wall of continuing education certificates. "The Henderson motion," I said, placing the court filing on her desk. "Can you walk me through the submission process?" She glanced at the document without concern. "Standard electronic filing. Your draft came through Monday evening. I reviewed it Tuesday morning and submitted before the deadline." "This isn't my draft." Her expression remained neutral. "The system shows your user credentials created the final version. Perhaps you made revisions after hours?" I had worked with enough witnesses to recognize deflection. "My access logs show no activity Monday night. The metadata indicates document creation at 3:41 a.m. System glitches happen. The important thing is meeting court deadlines." She returned to her discovery review, dismissing my concerns with practiced efficiency. Back in my office, I began systematic investigation. The billing system revealed a pattern spanning 3 months. Late-night entries under my code, always between 2 a.m. and 4 a.m., always on cases Arabella managed. The Henderson motion represented the most egregious example, but 17 other filings showed similar anomalies. Each altered document weakened our client's positions. Motions that should have sought dismissal instead requested extensions. Discovery requests that should have been broad became narrowly focused. Settlement negotiations that should have been aggressive turned conciliatory. The pattern suggested deliberate sabotage rather than system errors. I contacted our IT director, Zachary Aldrich. No relation to our general counsel despite the shared surname. His forensic analysis revealed sophisticated credential spoofing. Someone with administrative access had created mirror accounts that mimicked legitimate user profiles. "The logs show your credentials active during times you weren't in the building," he explained, pointing to timestamps on his screen. "But the IP addresses trace to internal terminals, someone with physical access to our systems. Only 3 people possess the administrative privileges necessary for such manipulation: myself, the managing partner, and our compliance advisor." The crystallized during my review of the Pemberton case, another education law matter involving teacher tenure rights. I had prepared a motion for summary judgment based on constitutional grounds. The filed version argued for extended discovery instead, guaranteeing months of additional litigation and legal fees. Our client had lost a winnable case because of that strategic reversal. I printed every suspicious filing and spread them across my conference table. The pattern became undeniable. Arabella had systematically undermined our client's interests while generating additional billable hours. The financial motive was clear. Longer cases meant higher fees, and her performance bonuses were tied to department revenue. The scope of the betrayal extended beyond simple document alteration. She had accessed privileged attorney-client communications, reviewed confidential strategy memos, and used that information to anticipate and counter our legal arguments. Every case she touched had been compromised from within. I found the smoking gun in our backup servers. Arabella had been downloading client files to external drives, creating copies of sensitive documents that should never leave our secure network. The access logs showed systematic data theft spanning 18 months. But the most damaging discovery came from the Henderson case specifically. Arabella had been feeding information to the opposing counsel's office. Email metadata revealed regular communication with their litigation team, sharing our strategy documents and settlement positions in real time. She had sold out our clients for money and career advancement, using her position of trust to systematically destroy cases from within. The betrayal was complete, calculated, and devastating in its scope. 23 cases compromised, 14 clients who had received inadequate representation, hundreds of thousands in legal fees generated through deliberate case prolongation, and my reputation hanging by the thread of documents I had never written, bearing my forged signature. The kala was overwhelming, but confronting her would require careful planning. She still controlled our filing systems and had demonstrated sophisticated technical capabilities. One wrong move could result in destroyed or additional sabotage. I needed allies, and I needed them fast. I called Zachary Pemberton at 6 a.m. Monday morning. As our senior litigation partner, he had the authority to freeze system access and initiate emergency protocols. His voice was groggy, but sharpened quickly when I explained the situation. "Meet me at the office in 30 minutes, he said. "Bring everything. The Prio firm's emergency conference room felt different at dawn. Fluorescent lights hummed overhead as I laid out the across-the-mahogany table. Zachary examined each document with methodical precision, his expression darkening with every page. "This is catastrophic," he said finally. "We need to contact the Legal Ethics Enforcement Division immediately." Within 2 hours, our conference room had transformed into a command center. Fraud Strategy Enforcement Chief Olivia Grant arrived with a team of investigators, their laptops and bags spreading across our normally pristine space. Her reputation preceded her 15 years prosecuting attorney misconduct, with a conviction rate that made defense lawyers nervous. "Mr. Wellington," she said, reviewing my compiled, "this appears to be systematic fraud with multiple victims. We'll need complete access to your systems and client files." Arabella arrived at her usual 9 o'clock, coffee in hand, completely unaware that her world was about to collapse. I watched from the conference room as she settled at her desk, checking emails and reviewing her calendar with practiced efficiency. Zachary approached her workstation with 2 investigators flanking him. The conversation was brief and professional. Arabella's face went pale as she realized the scope of what was happening. Security escorted her to the conference room where Chief Grant was waiting. "Ms. Aldrich," Grant began, "we have suggesting systematic document fraud and client betrayal spanning 18 months. You have the right to legal representation." Arabella's composure cracked immediately. Her hands trembled as she reviewed the printed her own access logs, the forged documents, the communication records with opposing counsel. The technical trail was irrefutable. "I can explain," she said, her voice barely audible. The pressure to generate revenue was enormous. Partners demanded higher billable hours, better case outcomes, increased department profits. Grant leaned. "So you decided to prolong cases by sabotaging your own clients?" "It started small," Arabella continued. "Minor delays, additional discovery requests. But the bonuses kept coming, and the partners praised my revenue generation. I thought I could control it." The confession unfolded over 3 hours. Arabella detailed her systematic approach, accessing privileged communications, altering filing deadlines, sharing strategy documents with opposing counsel in exchange for case prolongation agreements. She had turned legal representation into a profit-maximizing scheme at her client's expense. The financial scope was staggering. Over $400,000 in unnecessary legal fees. Settlement amounts reduced by an estimated $200,000 due to compromised negotiating positions. 14 clients who had received deliberately inadequate representation. But the Henderson case revealed the deepest betrayal. Arabella had been receiving direct payments from the opposing counsel's firm, $5,000 per month, for 18 months, in exchange for real-time access to our litigation strategy. She had literally sold our clients' interest to their adversaries. The forged signatures were necessary, she explained with disturbing calm. I needed documents that appeared to come from senior partners to maintain credibility with opposing counsel. Grant's team worked methodically through our systems, documenting every compromised file and fraudulent transaction. The collection took 6 hours, with investigators photographing documents, copying hard drives, and interviewing affected staff members. The partnership meeting that afternoon was brutal. 12 partners gathered in our main conference room as Zachary presented the full scope of Arabella's betrayal. The financial liability alone could destroy the firm. Client lawsuits, malpractice claims, potential criminal charges. "We have no choice," said Zachary Hartwell, our managing partner. "Full cooperation with the investigation, immediate client notification, and complete transparency with the Bar Association." The next weeks blurred together in a cascade of legal proceedings. Arabella was arrested on charges of fraud, conspiracy, and professional misconduct. Her law license was immediately suspended pending full disciplinary review. The state bar opened formal proceedings that would likely result in permanent disbarment. Client lawsuits began filing within days. The Henderson family retained outside counsel and sued for malpractice, seeking damages for the compromised settlement and additional legal fees. 13 other clients followed with similar claims, creating a litigation nightmare that threatened the firm's existence. I found myself testifying repeatedly before the Bar Association, in depositions for client lawsuits, and eventually in Arabella's criminal trial. Each session required me to relive the discovery process, explaining how trust had been systematically exploited and clients betrayed. The firm implemented emergency protocols, new document verification systems, enhanced access controls, and mandatory ethics training for all staff. We hired an outside compliance firm to audit every case Arabella had touched, identifying additional victims and potential liability. But the most difficult conversations were with the clients themselves, sitting across from the Henderson family, explaining how their trusted legal representation had been compromised from within, watching their faith in the legal system crumble in real time. "How do we know this won't happen again?" Mrs. Henderson asked, her voice hollow with betrayal. I had no adequate answer. Trust, once broken, requires years to rebuild. The criminal trial concluded 6 months later. Arabella pled guilty to fraud and conspiracy charges, receiving 18 months in federal prison and full restitution orders. The Bar Association imposed permanent disbarment with no possibility of reinstatement. Our firm survived, but barely. 8 partners left to start independent practices. Client trust remained fragile, despite our transparency efforts. The financial settlements exceeded $2 million, forcing us to restructure our entire partnership agreement. I spent countless hours helping other attorneys who had discovered similar betrayals in their own firms. The legal community was smaller than people realized, and Arabella's case had exposed vulnerabilities that existed everywhere. Trust-based systems were only as strong as their weakest participant. The final piece of justice came when Chief Grant's investigation revealed that Arabella had been planning to leave the firm anyway, taking stolen client information to a competing practice. Her betrayal had been calculated preparation for career advancement, using our clients as stepping stones to personal success. Standing in the empty conference room where it all began, I realized that some betrayals cut so deep they change everything that follows. 12 months later, I stood in my new office overlooking Trade Street, watching Charlotte's legal district buzz with morning activity. The nameplate on my door reads simple and clean: Wellington Legal Ethics Consulting. The transition hadn't been easy. Leaving the partnership meant walking away from 20 years of built relationships, established client bases, and the security of a large firm infrastructure. But some betrayals create opportunities disguised as endings. My phone rang constantly now. Attorneys from across the Southeast called seeking guidance on internal investigations, document verification protocols, and compliance system design. The legal community had learned that trust required verification, and verification required expertise. "Mr. Wellington?" My assistant's voice came through the intercom. "Zachary Aldrich from the Morrison firm is here for his consultation." I smiled at the irony. Another Zachary, another firm discovering that their trusted systems had been compromised from within. The patterns were always similar: gradual access expansion, document manipulation, client information theft. The methods evolved, but the fundamental betrayal remained constant. Zachary Aldrich entered looking exactly as I had 18 months ago. Confident attorney suddenly questioning everything he thought he knew about his own practice. His firm had discovered altered settlement agreements and missing client funds, traced back to their managing partner's unauthorized access. "How do you rebuild after something like this?" he asked, settling into the chair across from my desk. "One verified document at a time," I replied. "One honest conversation at a time. One ethical decision at a time." I now operate a litigation strategy firm for ethics-sensitive matters, helping attorneys navigate the complex intersection of legal practice and professional responsibility. The work felt more meaningful than anything I had done at the partnership. The Henderson family that had become unexpected allies, referring other victims of legal malpractice to my practice. Their trust, slowly rebuilt through consistent transparency, had become the foundation for everything that followed. Arabella remained in federal prison, her appeals exhausted. Chief Grant's investigation had uncovered similar schemes at 3 other Charlotte firms, leading to a comprehensive overhaul of legal ethics enforcement statewide. The ripple effects continued expanding, touching practices far beyond our original case. My former partnership had stabilized under new leadership, implementing the verification systems we had developed together. They referred complex ethics cases to my practice now, a professional relationship built on shared understanding of how quickly trust could be destroyed and how carefully it must be rebuilt. The evening sun cast long shadows across my office as I reviewed the day's case files. Each investigation told a similar story: professionals who had trusted too completely, systems that had assumed too much, and institutions that had verified too little. But there were success stories too: firms that had implemented proper oversight before betrayal occurred, attorneys who had questioned suspicious patterns early enough to prevent damage, legal practices that had learned to balance trust with verification. My phone buzzed with a text from Chief Grant. "Another case for you. Major firm in Raleigh. Similar pattern to Arabella's scheme." I gathered my files and prepared for another investigation, another opportunity to help rebuild what betrayal had broken. The work never ended, but neither did the satisfaction of restoring integrity to a profession built on trust. Outside my window, Charlotte's legal district continued its daily rhythm. Attorneys hurried between courthouses and client meetings, most never suspecting that their trusted colleagues might be systematically betraying everything they had built together. But some of them would call my office eventually, and when they did, I would be ready to help them navigate the aftermath of discovery, the complexity of investigation, and the long process of rebuilding trust. It was finally over, and the silence felt earned.